Good afternoon, everyone. I think it's morning in some areas. Judge Sean, I don't know if it's morning or afternoon there, but I would like to welcome everyone from all the horizons where you are. Welcome to this webinar. I would like to welcome our panelists in a very special way. I would like to welcome our attendees. You can see we're now at 58, so thank you so much for taking time to join us. So this is a webinar that has been organized in partnership by the East Africa Law Society, in partnership with the Attorney General's Alliance, and would like to appreciate the dedication of everyone who has made this possible. The East Africa Law Society Secretariat, our partners at the Attorney General's Alliance, and we just want, we are very hopeful that at the end of this webinar, we will not only have learned, had a new perception of the topic, but we would also have achieved some networking and also just to be mindful of what is happening elsewhere. So that Attorney General Alliance has had a long partnership with the East Africa Law Society, and we've held a couple of trainings. In 2018, there was one that was held in Kigali on cyber crime and electronic evidence. We've also had one held in Mombasa, which was on transitional crime. So the leadership of Attorney General's Alliance, led by Marcus Green, has always been able to step up and provide the kind of strategic alliance that we at East Africa Law Society are seeking out for. And we really thank the Attorney General Alliance for this commitment and passion that they have shared to continuously see that the East Africa Law Society is growing for the benefit of all our members, which is one of our core values. And I would also like to recognize the dedication of all our speakers who are here for this event, who have been drawn from all over the world. Judge Sean Wallace from the United States of America. So you can see from this kind of harnessing of talent and passion, we really expect to have a quality mixture and of deliberation that will be very, very valuable to our members who have joined in. So I would also like to thank our secretariat who have really worked as a lean team to ensure that despite the disruption that we're undergoing right now, that there is still a lot of continuity in terms of the objectives and what we're looking to achieve as the East Africa Law Society. And I would just, in a special way, want to thank them. The East Africa Law Society is inclusive of membership from the national bars of Uganda, that is the Uganda Law Society, Kenya, that is the Law Society of Kenya. We have the Tanganyika Law Society, the Zanzibar Law Society, we have the Rwanda Law Society, the Burundi Law Society, and our latest addition, which is the South Sudan Bar Association. Of course, we cannot introduce this webinar without acknowledging the disruption that we have all undergone with the COVID-19 pandemic. But it's very encouraging to see that despite that, we have all looked out for ways that we can continue. We have all looked out for ways that we can maintain the partnership that we harnessed before COVID. And we are looking forward to even more value that we are going to add onto ourselves, even after the COVID, as we get back to business as usual. So, of course, the legal profession has been one of those professions that was hard hit by the pandemic, starting from our judiciary, which most of our judicial systems were closed down. Our working law firms, anywhere where you have law, has really, really been disrupted. So we hope that we will focus on on looking at the challenges, especially in the courtroom. And by the end of this webinar, we will have at least had an eye-opening section where we can work towards unlearning and learning and see how we take out the positives of this pandemic and push ourselves forward as we prepare to go back to our normal, if that will ever happen. So without further ado, I would like to welcome you, Mark Green, to give your opening remarks. And thank you so much once again. So welcome, Marcus.
Thank you, and good afternoon to you, and good morning to Judge Wallace. I'm delighted to be able to open this webinar this morning, and I am delighted to kick off a conversation about virtual courts, which is extremely important given the current pandemic. Before I do that, I want to just give you some greetings from the Executive Director, Karen White. There would be no AGA Africa without AGA, and so we thank Karen for her leadership and continued support of the African program. I also want to acknowledge the East Africa Law Society and for its stalwart leadership, Mr. Willie Rubia, the president, as well as Mr. Hannington Amal, Chief Executive Officer. It is an absolutely essential that we continue to engage in this work. COVID-19 is indeed a speed bump, but it's not a stop sign. We continue, the work continues, because if we do not, the work that AGA Africa has done with respect to training and building capacity in 8 different countries on the continent is no short of a miracle in the short time that we've been in existence. And if we don't continue it, one thing you should be sure of is that the criminal activity will not stop. So it's incumbent upon us to find creative ways to engage, creative ways to continue our work. Now, it's suboptimal for us to be meeting like this, to be engaging in this way, but it's part of the challenge of what we do as lawyers, and it's what we do as people. When there are challenges, we figure out new ways to accomplish the same task, and that's what we're doing. So with that, many of you know who we are at the AGA. You know that we are in 8 different countries. You know that we train on the rule of law and on issues related to transnational crimes, and we're going to continue to do those things. But this particular topic is very, very timely. The idea of a virtual court, of a virtual workplace, is extremely important. With it comes challenges, because just as we're conducting business this way, so are banks, so are all your major corporations, and it is blood in the water for criminal activity and for hackers. So when we talk about the virtual courts, we can't talk about the virtual courts without talking about virtual crimes, without talking about cybercrime, and the need for cybersecurity. It's all related. If this is going to be our new normal, at least looks like for the near future, we need to make sure that we have mastered the skills to navigate the systems, but more importantly, taking all of the precautions that are necessary in order to avoid being a victim, and not just individually, but at our institutions. All of this, COVID-19, and everything that's happened in the world, including the killing of George Floyd, is a reminder of something that AGA Africa always touts, and that is we live in a global village. we're all connected, right? So this pandemic that is rumored to have started in a small town in China has completely gripped and paralyzed the world. If that is not evidence of our connectivity, I don't know what is. And so just as health-related issues connect us, so does criminal activity. Crime knows no borders. Criminals know no borders. And we, as the law enforcement community, as a judicial community, ought not to know borders. We need to match their efforts with counter efforts. We need to understand the technology the way they understand the technology, and we need to stay ahead of it. And so, even though that this is a challenge for AGA Africa, we're ready to meet the challenge, and we have to meet the challenge. And so I'm going to leave you this morning with one of my favorite quotes from one of my heroes, the late, great Dr. Martin Luther King, that I think sums up the connectivity of humanity. In his letters to a Birmingham jail, he wrote that we're all connected and we're all caught up in this unescapable network of mutuality, bound to a single garment of destiny. And so as you go forth to do this webinar, you're really doing work that acknowledges who we are as people. We're sharing information, we're working together, and we're working across borders. And we're underscoring this notion that we're all in this together. So with that, I want to again thank the East African Law Association. I want to acknowledge our partnership, and I want to acknowledge AGA Africa's continued commitment to partner. So with that, have a fantastic webinar and enjoy your day. Thank you.
Thank you, Marcus. Thank you for those encouraging words, and thank you for opening for us. And once again, we also appreciate our Secretary General, Asmani Saad, who has delivered the welcoming remarks on behalf of the President. My colleagues, I know we delayed the start of this conversation, but please stay on course. You are set to receive probably one of the best trainings ever delivered by the East African Law Society in modern times. Allow me to recognize our facilitators for the day. They are 4 in number. We are honored to have Judge Sean Wallace, who is a judge of the circuit of the Court of the 7th Circuit of Maryland. Judge Wallace will be taking us through the bench's feedback on how lawyers or counsel conduct themselves during judicial proceedings, specifically in relation to virtual proceedings. And I'm pleased to confirm that Judge Wallace is highly experienced, and he will be with us only for a short time because in the next few minutes, he will be commencing another virtual court proceeding. So we'll not be able to have him for a long time, but for the short time, we will enjoy being with him. I'm also pleased to introduce Mr. Stephen Kepnes, who is probably well known amongst us in East Africa, one of the leading names on technology and intellectual property practice in the region. Mr. Kepnes is a senior partner at Kepnes & Odhiambo, LLP, which is based off Nairobi. And this afternoon, Kepnes will be taking us through basically the concept of virtual proceedings and virtual courtroom, what it means, the challenges, advantages, and where the future is. Following closely will be Faith Masharia. Faith is a partner in the litigation function at Africa Legal Network, Anjarwala and Kana, based in Nairobi. Faith is also an arbitrator, and I'm also pleased to observe that Faith is my classmate and a former practice colleague at Anjarwala and Kana. Faith will be taking us this afternoon through counsel's presence in a virtual courtroom, basically navigating the challenges of being behind the computer while still expected to deliver robust advocacy within the courtroom. And finally, Olu. Olu is the easiest to pronounce, but his name is Olubumi Salami. Olubumi is the Assistant Polk County Attorney in Iowa, United States of America. He joins us with extensive experience because on his day-to-day practice is tasked with ensuring that Polk County State's Law Office is able to deliver on its mandate, which is basically to prosecute and defend cases on behalf of the Polk County. And that means, especially in these challenging times of COVID, is making extensive use of virtual proceedings. And we are lucky that we have this wealth of experience this afternoon to guide us. And ladies and gentlemen, you have the function of asking the questions with you and dropping comments. As the session proceeds, please feel free to drop them there. We will take recognition of each one of them, and as much as possible, we will have them answered. Just ensure, while doing this, you try as much as possible to specify to which speaker you are addressing your question to. And with those remarks, ladies and gentlemen, allow me to welcome Judge Wallace to take us through the first part of this session. Welcome, Judge Wallace.
Thank you. It's a pleasure to be with you, I guess, at least virtually to be with you. I wish I could be present in person, but that's the reality of our world at the moment. So before the pandemic, my experience with virtual or remote proceedings was limited to webinars like this one, and to Zoom meetings, which were often awkward events with people speaking over each other and the like, not intentionally, but because they lack the ability to get the social cues that we all are familiar with and use in our daily lives in personal interactions. Obviously, my experience with these has changed dramatically this year. To give you a little bit of background, I'm from Maryland. Maryland is one of the original 13 states of the United States, and it borders Washington, D.C. on the East Coast. My jurisdiction, Prince George's County, is a jurisdiction of about 1 million people, and we have been badly hit by COVID. Just to give you some sense of what that is, as of last night, when I last checked, we had 18,572 confirmed cases of coronavirus here in the county and 658 deaths. This is all since the pandemic hit us in early March. Compare that, to give you some frame of reference, to compare that to Kenya, of which we are about 2% of the population. In other words, you have 50 times as many people, but we have 3 times the number of confirmed cases that the whole country of Kenya has, and we have 4.5 times the number of deaths. So my jurisdiction was very hard hit by this disease, and we've been closed completely since March 16th, I think it was. And all hearings since then have been conducted remotely or virtually. Now, I know I have 10 minutes, and I've presented with Mr. Kepnes about 4 times before, and I always precede him, and it seems like every time that I've stolen some of his time and some of his content. And in order to avoid being accused of being a serial criminal, I'm going to do my best to avoid that. So from a judge's perspective in virtual hearings, there's probably 3 things that I think you should be aware of. First, and these are kind of the same things that you should be aware of in a courtroom, but magnified because of the nature of a virtual hearing. So from a judge's perspective, the most important point is that you and your face are always on view. In a courtroom, well, let's say watching hearings, virtual hearings myself, where I see my own picture, I've been amazed at my facial expressions during the course of the proceedings. And as a result of that, I've consciously tried to adjust my expressions so as not to react as visibly as apparently I've been doing for 18 years. You should be aware of this, and you should do the same thing as an advocate. Usually when a witness testifies in the courtroom, all eyes are on the witness. Yes, you're all theoretically visible to the judge, but the judge is watching the witness when they're testifying. But in a virtual hearing, your square, your picture with your face is right next to the witness. And so the judge can very easily see, with moving his eye just an inch, his vision just an inch, he can see he or she, your facial expressions. And you should be aware of that. So, for example, in a virtual hearing, if you show disdain or if you show incredulity at a witness's testimony, that's okay if you have the evidence that you're going to present later to show that that witness's testimony is not believable, if you've got the evidence to contradict it. But if instead you show shock or dismay at what's being said, and you don't have evidence to contradict it, you may be signaling to the judge that you have been fatally hit by this testimony, that your case has been fatally hit, and that you are headed to defeat. Now, obviously, the judge is not going to make his or her decision, based on your facial expressions, but unconsciously, the judge will say, that was a very important witness with very important testimony, and that will embed itself in the judge's consciousness for when they make the decision. So you need to be very conscious of the expressions that you have during the course of the hearing. Use a poker face to the extent that you can. And again, I thought that's what I was doing as a judge for 18 years. And clearly, once I've seen myself on these virtual hearings, that's not what it is. So I would, again, implore you to be conscious of that and to of what you're showing, and to do your best to avoid showing any kind of expressions that you do not want to be communicated to the judge. Also, the second thing is, in a virtual hearing, avoid the problem that I described in those Zoom meetings that I've been in, where people cut each other off unintentionally. When we're in person, we all get social cues as to when someone has finished their what they have to say. And so we don't have those in a virtual hearing. In a virtual world, those cues aren't there. And this is okay if it's an opposing witness for you to cut them off. Lawyers, of course, strategically will interrupt witnesses that are opposing to them to avoid having either to lead them or move them into another area of discussion, or to avoid having them present harmful testimony. That's okay. But you don't want to intentionally cut off and interrupt your own witnesses. You don't want to interrupt testimony that is helpful to your case. And that's much more apt to happen in a virtual hearing, given the nature of how these hearings go. And often there is delay, and so you need to be conscious of that as well. And then the third thing is that you need to remember in virtual hearings that everything surrounding you, you're bringing into the hearing. So when we first started doing these hearings, I did them from home. And so I wasn't going to do them in the bedroom. But I ultimately, if you have the option to put up a virtual background, which I did, I had a picture of my courtroom, the bench, so it looked as if I were sitting on the bench in my courtroom to anybody on the call. So there's that. Now, I'm in my chambers here, so you just see the books and not too exciting. But if you're doing it from somewhere that's not as professional looking as you would like it to be, put up that virtual background if that's at all possible. The other thing is that everything in your hearing is being brought into that proceeding. So in some of these hearings, people have been, again, the lawyers have been at home, and that's fine. I understand, everybody understands that. But if your spouse is in the house and is yelling at one of the children, the judge and everyone else in the hearing will hear that. And that distracts from the image that you're trying to present as your client's position is the most important thing in the world. And it's unintentional, of course, but it still kind of undercuts your doing it. So your spouses, and I've heard spouses, who are all working. So one spouse is on the hearing with me, another spouse is working virtually from their work, and they're yelling at one of their employees about something, and maybe some profanity comes through, or they're yelling at one of the children. Both of those have occurred. It just takes away from the professionalism that you as an advocate have, and you should be aware of that. So try to seal yourself off from those sounds. And interestingly enough, some people, I think they thought that they were doing that. I see Mr. Kepnes wearing headphones. Headphones cough off the sound coming to you. But if he were speaking now and his microphone was on, we would still be hearing him. So headphones are not a solution to this problem. If there are pets in the house and they're barking, if there's outside noise, if there's workmen doing work outside, if there's sirens going past you, be conscious of that. So they may not sound like they're gonna that they're drowning you out, but I would wait for that siren to pass. Apologize for it and just say there's an ambulance going by. In case you didn't hear, I'm going to repeat what I had to say. So I think those are the three big points that I want to make from a judge's perspective. I think I've avoided my repeated acts of criminality with regard to Mr. Kepnes. And I would finally close by saying, look, the world is changing. This is the most dramatic change in my lifetime. And those who adopt and adapt to that changing world are the ones that are going to succeed. And that's true in the area of law. It's true for advocates. So the advocates that adapt to this new reality of virtual hearings are the ones that ultimately are going to do better in court, and thus will be doing better in their legal practice, whether it's as a prosecutor or whether it's in private practice. But kind of just be conscious that this is a very important topic that's being covered here, and I would certainly exhort all of you to listen carefully, take notes vigorously, and implement these discussions as well as you can. As was mentioned earlier, I have to go in about 15 minutes to start conducting my docket for the day, virtual hearings. I'm going to watch as much as I can. I'm going to leave, and I may be popping in and out. When I leave, I'll turn off the camera so you won't see my empty courtroom. But thank you again for the opportunity, and I'm going to turn it over to Mr. Kepnes.
Thank you so much, Judge. Thank you for the words of wisdom and guidance. And if you get a chance this morning from your end, please feel free to come back in, step back in, and answer a few questions. I know our members will be very much eager to hear more from you. Thank you so much.
Thank you.
Now, may I now invite Mr. Kepnes to take us through the concept of virtual advocacy. Kepnes, welcome.
Thank you very much, Hannington. It's a pleasure to be here, and absolutely always a privilege to follow Judge Wallace, not just as my senior, but very incisive speaker. Very interesting points that you raised, which in my experience of virtual courtrooms again this year, we've seen all sorts of interesting, unnecessary distractions in the courtroom. But thank you very much, Judge Wallace, for pointing that out. Always a privilege to share the panel with you. Now, my screen, I don't know if you can see my screen. Can you see my screen?
Yes.
Excellent. Okay. So what I need to do is get there as well. My apologies. Okay. Assuming everybody can see my screen, I'm just going to proceed with the presentation. So talking about virtual advocacy, I mean, literally a virtually new area of practice and procedure, which perhaps, even last year was never really being considered, except as an addition to what was already available as part of regular advocacy. Now, again, before I start off, what I'd like to do is to just provide a little background into which I often find very helpful for attendees. A little background into the World Wide Web and how it works. So, quick 5 minutes. The Internet versus the World Wide Web. The Internet is a series of networks that allows us to access the World Wide Web. And the World Wide Web, obviously, then is where the content resides. This is then the interconnection between the network that allows us to get into the content. On the left side of your page, you have a sample of a web page or web link, a URL, specifically for the NewYorkTimes.com, which shows you the different components of that link. This is what you would click on if you're seeking to, read the New York Times. And if you went to the NewYorkTimes.com and clicked on technology, then the web link would change. The web address would change to include /tech/ so that it can take you to the technological issues around, what your interest is in the NewYorkTimes.com. So basically, what happens on the back end is that there's a series of web pages, so that as you click from one link to another, you could be on the New York Times looking at technology issues, and you have an interest in a particular case, a legal case. And when you click on that link, because perhaps it's provided as part of a story in technology, you click on that link and it takes you straight to, say, the law case law part of the web page, or it could be a link that emanates from a certain legal platform that provides cases. And before you know it, the place you started is not the place you end. So there's a series of web pages, and this is why it's called the web, similar to a spider's web. It's a complex web of web pages that are interlinked. What then happens is that these web pages the interlinking of the web pages allows web users to navigate easily without having to retype each uniform resource locator, each URL. Now, a web search engine is comprised of the following. It's comprised of a search robot, which is in the background analyzing and indexing web pages. So you have a robot which seeks to just index and catalog every single web page that exists out there, anything that comes on as a new web page. And then you also have the interface, which is where the questions are posed. And why I have this is because I just want you to understand that the ease with which the World Wide Web works is really similar to how we operate in a library as law professionals. You go into a library, instead of walking up and down the different rows or shelves of books seeking to look for a book on virtual advocacy, you simply go to a computer or the catalog cards which are available anywhere within the library. You look up that particular book on virtual advocacy, and it tells you that this is on the second floor, it is on shelf number 47, and you go straight to find the books that you need. So it's a similar relationship between the World Wide Web and search engines. So you have a librarian called the search robot, which is seeking to look for different books, different web pages that have come onto the web. And then you have the web browser, who's the librarian working in the reference desk. So what happens with the librarian who does acquisitions is you bring that acquisition, that new web page, that web page is cataloged, and as soon as it's cataloged, it's put in a place that is available, which is you on the search engine looking for that particular web page. So this is what allows us to easily maneuver up and down the different web pages that we have. Now, let me move on to sort of the red meat of what I'm here to talk about. And mine is really the easy part, to do the introduction. The heavy lifting is being done by the more competent people. That will be Olu and Faith. So we'll just stick to sort of the basics about what this is all about. Again, as a matter of introduction, what is cyber justice? We're dealing with cyber justice as much as we're dealing with cyber courts. And I put it to you that if justice is there for then maintaining or administrating what is just through the impartial adjustment of conflicting claims or the assignment of merited rewards. In terms of how justice is dispensed in the brick and mortar world, then online justice is simply the ability to do the same thing. And the words therefore online and cyber are interchangeable. So undertaking the administration of justice, undertaking the adjudication over conflicting claims in an online fashion could be tagged as cyber justice. Online dispute resolution, therefore, is also similar to, in many ways, the ways we resolve disputes in the brick and mortar world. It's a collection of conflict resolution methods that utilize online technologies to resolve disputes. So again, taking what we have in the brick and mortar world and applying that to an online setting, so that it's not just through litigation, but it could be arbitration, could be mediation, could be negotiation. And contrasting that with alternative dispute resolution, which really is traditionally was all forms of dispute resolution outside of traditional litigation. And this was seen as a method of trying to perhaps enhance the expediting of justice, provide a form that allows those who are disputing to perhaps not break the relationship entirely. And I won't bore you with the details of ADR, but basically ODR and ADR have a very strong interplay with one another, so that ODR originally intended to address dispute resolution between parties in an online setting is no longer the case. ADR is viewed to encompass ODR methods, and the reverse is true as well. ODR is seeking to encompass ADR methods of dispute resolution. So you would use technology and online platforms through ADR, while in ODR you'll seek to apply the principles and practices of ADR. So that what you can see through online dispute resolution is just another acronym seeking to create an understanding as to how alternative dispute resolution methods can be utilized. Now, we come into the courtroom where litigation in the brick and mortar world was considered to be one means of resolving disputes, but now we are finding we can use the online platform. It is in fact litigation, an online method of resolving disputes, where the courtroom has migrated onto a platform where the courtroom and the means of filing, the means of advocacy, the means of sharing documents is all happening on a platform. And therefore virtual courts, in my view, is a platform that allows the access of video and audio. Sometimes it could be the or, but in more often than not, you require to have video because there's a lot of face-to-face engagement which needs to happen. So it's a use access of audio and video among and between the different court parties who are involved in the proceedings. It also allows for the sharing of documentation. So of course you have the judge on the one hand, you'll have counsel on the other, counsel for the different parties. You may also have the different litigating parties themselves who are available, who may or may not be in the same time and space with their lawyers. As you can see, therefore, it means that the kind of place we are moving to could provide a situation where I am in one jurisdiction or I'm in one location, my client is in an alternatively different location, we are appearing before a judge who's in a different location altogether, and justice is dispensed. A virtual court platform allows for the payment of fees and fines as well. So we're not just talking about the virtual court being the court where Judge Wallace is about to get into in order to hear parties arguing for one client or another. I would expand that ability, and this is quite poignant, particularly today in Kenya, where Nairobi, the judiciary has indicated that all courts in Nairobi will now undertake electronic filing, and therefore any party who seeks to file a case in any Nairobi court will have to make use of the online platform. Obviously, there will be teething problems, but quite momentous, because then the court is not just the courtroom. Strictly speaking, of course, you have the courtroom with the judge and the parties, but you have a platform where you can file your documentation, you can share documentation, you can pay fees, filing fees for the pleadings that you're filing. If it's one of those traffic offenses where you're charged and you have to pay your fine, well, you can pay your fine using the court platform. So it should also ideally at its best allow you to check the status of your file. A lot of the times when you're trying to find out what is the status of a matter, then you should go to the court, go to the court registry, pull out the file, get access to the file, find out what is the status of the file, etc. Sometimes you're trying to get certified copies of proceedings. Sometimes you're trying to get the actual order. So a virtual court platform should allow you to do all these things. In other words, everything that has been possible in the brick and mortar world should be possible in using the virtual court platforms. And obviously, COVID-19 has sort of provided an expedited move towards virtual courtrooms, virtual court platforms. And perhaps that's one of the positive things that COVID-19 would have done. What are some of the processes that are involved with regard to virtual courtrooms? Well, the whole process of engaging with the court system involves traditionally the payment of filing fees, filing of pleadings, service of pleadings, setting court dates for mentions, hearings, judgments, literally everything that's spelled out in typically your procedural law. And therefore, what is important going forward is that virtual courtrooms can allow us as practitioners or can allow litigants directly to use technology to undertake all those processes. Some of them are easier than others. It's easier to file your pleadings than it is easy to have witnesses attend and be examined. It is easier to pay filing fees than it is easier to serve your pleadings. How do you address aspects of service of pleadings where we have in our system in Kenya, you have a category of individuals called process servers who serve court process. So they do have to go onto the location, say registered address of a company to serve certain court summons, certain court pleadings. Well, if you are able to serve pleadings through a virtual means, then it almost means you don't need process servers. I can do it from my desk. But what are some of the challenges of service? Because typically when you serve, you'll swear an affidavit saying, I went to the premises on this date at this time and met this individual. What would be the equivalent of doing that in a virtual platform? What if you sent an email or you sent the service of someone through emails and the party you are seeking to serve had their server not working so that the email did not get through? What if you were not able to serve within the amount of time that was given by the court? So there are lots of challenges in terms of just trying to make the transition. Obviously, training is going to have to be key, not just for judicial staff, but for advocates as well. And the advocates through, for example, the EALS right now is seeking to train its practitioners across East Africa just to understand what virtual courtrooms are about. So training is going to have to be absolutely essential for all judicial staff involved, from registry staff to court clerks to the judges themselves, including litigants, I believe. I mean, there's no way you can sort of create a training for litigants, but litigants would have to find a way to keep current with the court processes. There must be seamless communication to all the parties. I've been involved in a couple of cases in the recent past where a matter was apparently set up for a mention before a judge, and we didn't receive the notification. We speak to the registry and they say, no, we sent an email. And when you eventually find out either it was an incorrect email or it was just dropped, the ball was dropped. They didn't actually send the email. And so communication, obviously, in terms of court process is crucial. This can be grounds for vitiating, an appearance where, a lack of appearance where a party did not appear and the same is treated as non-appearance. And there are certain consequences that arise from the court procedures for purposes of non-appearance. Reliability in terms of the accessibility. There must be reliable access for all the parties. Now, how do you assure this? Because this is all dependent on where you are, your service provider. This depends on things that can't be streamlined either by the judiciary or by the advocates on the one hand. So there just needs to be a transitional period, in my view, for the ability of parties who litigate regularly, and this would really mean the practitioners and perhaps certain litigating parties, and we have a couple of those in this country, to understand that when you are accessing the virtual courtroom, you must have a minimum level of access in terms of, for example, bandwidth, in terms of availability, the ability to hear. We've had jokes running around the country where in the legal system, that is, where an advocate was typing out saying half of the time I'm in the courtroom, it's spent saying, my honor, your honor, I can't hear you. Can you hear me? Can you see me? and you keep shouting. And I was in a courtroom the other day where one advocate kept saying, "Can you hear me? Can you hear me?" And we could all hear him, including the judge, but he couldn't hear us. And eventually started having a conversation with his colleague saying, "They can't hear me. I don't know what's wrong. The judiciary, they never do these things right." And it was quite hilarious because we could hear him literally. So a reliable platform. If we're trying to access justice, if we're trying to have a virtual courtroom, the platform must be absolutely crucial. There are different platforms that our judiciary has tried in terms of using for purposes of conducting proceedings. Zoom has been spoken about. It's perhaps more widely spoken about than others, but it has its challenges. What we're using today, GoToWebinar, you have GoToMeeting, you have Webinex, you have very many different platforms. The judiciary needs to perhaps get the right kind of advice in order to determine what's the most viable platform. Some platforms are good for purposes of engagement, but the kind of bandwidth that it requires, and I think GoToMeeting is one of those, the kind of bandwidth that it requires is excessive, which means if I'm a litigant and I'm not able to have that kind of those kind of data bundles to access that bandwidth, meaning I will spend more in terms of data bundles, then it means it's not a viable solution for me. Some of the fundamentals that need to be addressed in the context of virtual courtrooms has to do with, and this goes to the point I just made on reliable platform, but an agreement on the type of technology, on the type of platform. This needs to have been tested and is robust and will work. What's the mode of transmission, especially of documents? Are we just going to use email? Are we going to use a platform? So if the judiciary is saying we're having to undertake e-filing, then I need to have access protocols which allow me to get onto a certain platform that the judiciary is in control of, that I can file. How are we going to communicate with one another? The use of blockchain. Blockchain has been spoken about and bandied about quite a bit in the recent past, and I think it's one of the more viable methods. And there are different use cases for blockchain technology. But I think it's one of the things that can assure integrity in the different components of technology that will be used in a virtual courtroom or a virtual courtroom platform. Protocols for file transfer and exchange need to be agreed on. There must be redundancy or multiple distribution paths, because then if you have failure of one, you can always move to another. In other words, it creates reliability of the platform. Ability of litigants to utilize technology must be considered. I mean, how savvy are our litigants with regard to technology? At the end of the day, the litigants get advocates on whose behalf, who argue, who file, who do various things, including interact with the judiciary on their behalf. But if the advocates are assumed to have some minimum level of understanding, how bad would it be for a litigant who can't afford counsel and therefore has to engage with the technology on their own? As it is, trying to seek justice, trying to access justice is very intimidating for litigants without having to use technology to do so. There must be a certain level of comfort that judges have with technology. Obviously, Judge Wallace is one of those prime examples. His ease with which he embraces and uses technology in terms or in his courtroom. And a lot of judges are not like that. So there must be a way that the judiciary encourages its judges to come to grips with technology, not just through training, but sometimes through one-on-one, because different people have different rates of interacting and accepting that interaction. Data protection is a really big deal. If I am going to interact with a certain platform allowing me to exchange data, allowing me to file information which contains personal identifiable information, then you're talking data protection. How viable are the security protocols that are being used by the judiciary to secure data? Cloud storage and capacity. I've spoken in previous fora about the kind of storage capacity that I know Milimani courtrooms to have, but the judiciary generates crazy amounts of data on a daily basis, not just from pleadings that are filed, but from hearings that are happening. So storage and capacity is a really big deal that must be taken into account, as well as security of systems. And I should be heading towards the end so I don't run over time. What are some of the advantages? What are some of the ethical issues and the governance challenges? Well, it's clear, it's easy. Effectiveness, efficiency, we are still going on with the administration of justice. Just because we've been relegated to stay at home because of trying to reduce the infection rate of COVID, doesn't mean that justice, the administration of justice, must stop. The wheels of justice need to continue flowing. And so it's very effective. The use of virtual courtrooms, extremely effective. It can be efficient. It is reducing costs because, in fact, I was joking with a friend, for litigating lawyers, you'll often charge for excessive amounts of copies that you have to make to file in court. It is known that advocates sometimes may loosely use costs which are slightly exaggerated in terms of the actual number of copies they made. Well, you're reducing costs of accessing justice for the client, and that's a really good thing for clientele. It will expedite the administration of justice. It will provide greater integrity, certainly in this country. And I have been in certain litigations where I've had to provide data in a CD-ROM and give it to the judge directly. Well, of course, through the court clerk. And this was because it was documents that were supposed to furnish to opposing counsel. And because the information contained a lot of confidential information and data, which my client at the time was worried about being liable for, we had to hand it over to the judge and say, we've handed it over to you. If anything leaks, if anything goes wrong, then we gave it to the court and we can't be held liable for that. So using technology will greatly enhance integrity, but there must be certain standards of security. So integrity of documentation, it will reduce case backlogs because it means we can move a lot faster in terms of how cases are heard, cases are dealt with. Then it will enhance the reform of court processes. I can't think of any judiciary across the world who's not using COVID as an opportunity to reform and refine the various court processes. So I think this is just a great ability. Obviously, the more you're able to innovate, the more you're able to use and tweak the technology for your benefit, the better it is for everybody. Some of the challenges include, and I'll just run through this because I think my time is really running out. Confidentiality and data privacy. That continues to be a big concern. You might have technology, but you're not using the technology to the best of its capacity. You're not enhancing the security protocols in order to ensure that data privacy remains. So data security remains very critical. Time zone differences. Obviously, very early in the morning for the judge who's in Maryland, if you have different time zone differences for the purposes of administrating justice, then that needs to be taken into account. And that can be a challenge for purposes of having a virtual courtroom. You have aspects of fairness and equality with regard to online processes and accessibility. And this is the point I alluded to earlier, where you have different levels of understanding or interaction with technology by counsel, by litigants, by judges. So if you have that sort of lack of equality, it sort of creates a digital divide, it creates digital asymmetry. And therefore, then you can't really say that justice, you're accessing fair justice. You can't say that you're helping the administration of justice. So that asymmetry needs to be dealt with. And of course, this can't be dealt with in one fell swoop, needs to happen over time. Lack of public access to virtual courtrooms. One of the biggest reasons we have why courtrooms are open to the public is because justice needs to be, trials and court proceedings need to happen in public, save for cases which have the courts have ruled have to happen in camera, save for children cases and certain unique cases where there are certain aspects of secrecy that are necessary. But it's an important characteristic of justice administration for the public to be able to come into the courtrooms and create the confidence in the administration of justice in that particular system or that jurisdiction. So when we have virtual courtrooms, then, well, the guy off the street can't walk into Judge Wallace's courtroom and observe how justice is being administered, how the trial is happening. So I think that's a big problem that needs to be addressed. Lack of face-to-face contact. We are face-to-face, but are we really face-to-face? Particularly with regard to, and I think this will be covered by my colleagues, where the demeanor of a witness, not just how they look, and this little box that allows you to see the face, you might not be able to see the fidgeting fingers, the tapping feet. There's so many things that you will lack in a trial situation, which is absolutely crucial. Limited inspection and discovery. Inspection and discovery is a tool that we use, of course, in litigation. There's only so much you can do from the perspective of online access, and so I think that remains a challenge. Lack of technological standards that have been adopted seamlessly that would allow the acceptability across the board. Other issues would include, in my view, broadcasting of proceedings by the court. This would be, in one way, seeking to mitigate the lack of public access. But can the court do this? Is the court able to adopt a standard for broadcast? Security, cloud computing, all those, the other issues, I'll leave them sort of for you to read. The presentation will be made available. I'm conscious that I've run out of time. I think in my last slide, what we need to do as practitioners is be willing to engage with the technology, be willing to enhance our understanding, be willing to tweak our advocacy skills. They're advocates, they're lawyers, particularly in a hearing situation where you can get very gesticulative. You can, you have movement, you have perhaps limited movement. In this case, you're sitting in a chair, and an advocate might feel, I'm really constricted. Well, you can't stand up anymore. You can't sort of move up and down anymore. You must remain in that little square for the judge to see you. So we need to review and tweak our advocacy skills to take into account the uniqueness of virtual courtrooms. Self-training, relevant, continuous legal education trainings, observing decorum, and this is really what Judge Wallace spoke to, so I won't go into that. But logging in on time, muting your microphone, canceling video if you're not there, if your matter hasn't been called, because you don't need to provide unnecessary distraction to the courtroom. I have been in courtrooms where I saw an advocate come in the early days. He came in a t-shirt, and the judge we were dealing with, a very erudite judge, was correct to tell the advocate that he needed to dress correctly. Obviously, you need to dress appropriately, at least in the top half. I've seen a lot of memes going around of advocates dressed formally in the top half, but they might be wearing swimming trunks in the bottom half, which is not a problem. But that's the end of my presentation. What I've left on the last slide is really something that seeks to throw out an indication about where we might be headed. Artificial intelligence, is this something that would come into judicial practice? And I've discussed this with Judge Wallace in the past. Is this something that we shall see judges like Judge Wallace move aside and be replaced by machines? Is it possible? Maybe not in the near future, but certainly Estonia is one of the fewer countries that is already using robotic judges for small claims cases. And it's quite a unique thing. Estonia obviously is very, very ahead of the curve in terms of the use of technology compared to many countries across the globe. Thank you very much. That's the end of my presentation.
Thank you, Stephen. That was a refreshing introduction to the concept of virtual courtroom, and I believe quite a good build-up to the experience that the judge has shared with us. Now, may I invite Faith Masharia to take us through the next part, which is counsel's presence in the courtroom. Faith, the floor is yours. Faith, you are still muted. Please unmute.
Thank you so much for the opportunity, Amal. I was saying I think I'm lucky this afternoon in Kenya to be the only lady, and I think the youngest among the panelists to be presenting this afternoon. And therefore, I can lawfully defer all the questions, especially the difficult ones, to my seniors, Mr. Salami and Mr. Kepnes. Good morning, good afternoon, good evening to all our participants, depending from where you're joining us. It's our pleasure to have you this afternoon with us in this presentation. So I'll go straight to my presentation this afternoon. Can you still see me?
Yes.
Yeah, perfect. So I'll be looking at the topic remaining persuasive in the virtual courtroom, and just to pick from where Judge Wallace started by saying we have a new normal, and the new normal now is what we are calling remote hearings or virtual hearings, as you like. And what you're trying to discuss is ways which we can minimize the impact of the shift from the physical hearings to the virtual hearings. And above all, from what I can say from the presentation of Mr. Kepnes and the presentation of Judge Wallace, is that we need to remain patient and flexible when participating in the proceedings virtually under the new protocols. Even as the court, as much as the advocates are trying to adopt to the new normal, so are the courts. so that as they learn to operate their new environment. Now, we'll agree that in a virtual courtroom on a remote hearing, that time is a premium, right? And that being said, there are 4 points that I want us to take away, bearing in mind that time is a premium. So you're talking about having less time. You'll agree with me that it will take more time to argue a point in a virtual courtroom as it will take to argue a point or to make your presentation in a physical room. So I'm saying we need to be clear, we need to be cogent, we need to be concise, and we need to be on point. Those are the 4 things that I like us to take home. Now, closer home and even in Kenya, we've seen the East African and within the East African community, we've seen several courts issuing practice directions.
Sorry to interrupt. Yes, are you able to put your presentation on presentation mode so that we see it more clearly?
Yes, I haven't moved my slides. I haven't moved my slides, so it's fine.
Oh, thank you.
Yeah, so that's okay. So I'll just move. When I get to the next one, I will. So as I was saying that we've seen practice directions within several countries in the East African community. And I think that can be said about other countries in different jurisdictions, basically suspending the physical operations of the court and now adopting to the new normal, which is hearings virtually. And with that, having said that, I want us to discuss various advocacy skills and tips that we should keep in mind going forward to ensure that as counsel, we remain persuasive to the court and valuable to our clients, albeit virtually. Now, the first thing that I'd like us to look is at the oral arguments in virtual courtrooms. Now, this is the most important, in my view. It's the most crucial part of the hearing, as I was saying, because it allows you to outline your client's case in a precise way and directing the judge to better understand your client's case as they retire to review your submissions. And when you're doing so, there's some performance or oral aspect of advocacy that may be lost on a virtual courtroom. For example, dramatic pauses. As litigators, we love dramatic pauses. The nonverbal cues, reading body language, just as Mr. Kepnes has said, do not be able to see the tapping of the legs, for example. Establishing eye contact with the judges, with the witnesses, and even capturing the emotion of a case. These are some of the things that may be lost in a virtual hearing. But when you're doing your opening remarks, this is your opportunity to catch the court's attention. And what you're supposed to, or my proposal at this point, is that you're supposed to pick out your key facts, which you like the judge to take note of. You have to identify your disputed and undisputed facts and ensure that the court's time is not spent on issues or side issues. You don't have to belabor or use your time on issues that are not in dispute. Then you, after done that, you need to list the issues for determination by the court. You can do so through an agreed issues, if at all that is, you have that, or even through your submissions. And to tie it up, you have to reiterate your prayers being sought by the client. In a nutshell, you have to make your case clear and known by the judge from the beginning. Now, how do I go back? Yeah, I just need to go back to my other slide, sorry. Yeah, that one. So the next one. Then you go to the use of body, the body of the argument. So you've done your introduction, then you go to the body of your arguments. What do you need to do so that you don't lose the judge at this point? And you're looking at the use of evidence, for example. What you're saying is you need to ensure that your evidence, they cover all the facts. Remember, you've already outlined your facts, your key facts that you want the court to focus on. So you bring in your evidence to fill in the gaps and to address the facts that you have already listed to the judge. Then if you have a trial bundle, you need to, it could be very helpful in this instance, and you need to make deliberate preparations. because you don't want to lose the effectiveness of your oral arguments. So the electronic trial bundle, and I know you could have trouble if at all you've not interacted with this in a formal session or in a court session, but should be properly indexed, paginated, and bookmarked. And this will make your work easier when you're making your arguments. Then the bundle needs to make easy reference. For example, you can use navigable, table of contents. You can make the bundle word searchable for e-highlighting, for example. If you want to refer to a letter, for example, from the Revenue Authority, you can have your keywords. You can use the keywords to search, and you can quickly be taken to the relevant page of your submissions. You can also use hyperlinks where possible. And I think here I want to share a recent experience that I had in one of the matters before commercial division, where we were given directions to file submissions, very brief submissions, about 10 pages submissions, and it's what we considered to be complex matters, as most of the lawyers will do in their matters. And we were asked to hyperlink the authorities that we intended to rely on in the case. And one of the lawyers, I won't say who it was, in a nice way was asking the court what hyperlinking actually meant, and the court was not amused by that. So what am I saying? We're saying that we could be meeting with new terms and new technology for some of us. We need to be patient with our colleagues, and it's also good you can ask, or you can consult your colleagues where you think they're talking about a technology that you have not interacted with before. Then when you have an opportunity, you can screen share like I'm doing today on the IT platform. However, you have to do the testing, and you need to make sure that you are well informed of the keys that you need to press. How do I go back my arguments if I need to? How do I proceed forward? Or how do I jump, for example, to the relevant page if at all I have run out of time? What about use of statutory provisions and case law? How do you bring this about? Is it different from the way we've been doing in a physical courtroom? Let's see. Now, you need to mention and explain the relevant provisions of the statute. I think that's not new to us. Then you need to use case law to support the statutory provision. Then I think what's important here is that you don't need to overburden the court with a lot of precedent relating to one issue. Remember, I said that time is premium. So you need to know how to use your time effectively. Then you need to avoid block citations of cases. Take advantages of hyperlinks in your written submissions or written material if you can, and that has become increasingly the practice in the commercial division in Kenya. Then you ensure that the statutory provisions that you have cited and case law, they directly touch on your case. This is not the time to go around on a fishing expedition. As I said, you need to be clear and to the point. Now, then you've covered the opening statement, you've covered the body of the argument, and then you're going to the closing remarks. What do you need to do? You need to summarize your case in 2 to 3 minutes, right? Tying in all the arguments you have made vis-a-vis your client's case and the prayers your client is seeking from the court. The key is to ensure that the case to the court is put out in the most relatable way. Then I think pace is everything. Pace is everything, right? And you may need to have something, maybe a note on the side of your table to remind you to slow down. And I'm saying this because most of our judges, especially in these jurisdictions, they still write down the court proceedings during the hearings. And as such, it's important to pace yourself so that you're ensuring you're giving the judge enough time to note and to understand what you're saying. So pace yourself, remain audible, and speak slowly. As I've said, it could be important. Some of us, you can be tempted to speak, much quicker in the middle of it. So it could be good, maybe we can have a reminder, maybe put on the wall or somewhere else where the court cannot see, to remind you to slow down. When you seem to be rushing through the proceedings. Then it could be that you may need to ask questions to confirm that the judge is following. For example, you want to ask the judge, my lord, you like me to repeat the citation of the case? But this means you have to be keen. You have to be observing the judge through the camera to see whether he's following you up. I know there's a joke also going around in Kenya that advocates have become religious, more religious of late because they have had, saying several times to the court, my Lord, have you heard me? These are my prayers. So you may need to be keen to observe that and take note that the court is indeed following. Then you need also to monitor the demeanor of the judge where you can, to ensure that you're not going too fast or to ensure that you're not going too slow. So it means you need to have your eye as well on the virtual court to see how the judge is taking. You may need to look and see, is the judge taking notes? Is the judge asking questions, right? And these are some of the cues that may not change even in the virtual courtroom. And you know what it means if the judge, for example, is not taking notes or is not asking questions. It could be a good time for you to find out from the judge whether you're still together in the case. Now, how do you capture the attention of the court in a virtual courtroom? Remember, the advocates were used to taking over the courtroom. We like standing, we like expressing ourselves, we like using our hands when we think it's a point that needs to be emphasized. How do we capture the attention of the court in a virtual courtroom? I think the first point is you need to try as much as possible, if you can, to maintain eye contact at all times. And how you achieve this is by glancing directly at the camera, which is at the top. If you're using your laptop, depending on the model of your laptop, it's usually at the top of your laptop. So you need to glance at the camera so that you can be seen to be as if it was a discussion with the judge. Then you can also use visual aids if this is permitted, right? To create a map if allowed, right? I don't know whether it'll be permitted to use a pie chart. Maybe it's a commercial dispute that may need explanation of numbers. Maybe you may need to use a bar, for example, or a chart, whatever it is. If you're allowed to use visual aids that could, break the boredom of a voice and keep the judge, attention to your case, and if it's allowed, please make use of visual aids. Then you also need to keep your voice raised. I've said this, and speaking slowly, audibly, and concisely. And the other thing that you may need to do is to adopt a conversational style and interacting with the listener, right? Interact with the judge. As I said, you can ask questions. You can pose some question to the judge. My Lord, are we together? My Lord, will you like me to go through the paragraph again? And so on and so on. And I think most importantly, and this is something that Judge Wallace alluded to, do not speak over anyone. I mean, even in a virtual courtroom, we still have our ethics. We still have to be courteous, because the effect of speaking over anyone is much more pronounced in a virtual courtroom, and you may actually lose your audience. And where you realize that there's somebody who is speaking when you're speaking, for example, and it could be good that you keep quiet or give them a moment. Then you let them speak, then you can address the court. But we should, as much as possible, try not to speak over anyone. Now, I think in a virtual courtroom, we are seeing written advocacy in addition to the oral advocacy being more crucial, more than ever. So we need to be looking at the quality of the written material that you're producing, the quality of our pleadings, for example, the quality of the written submissions that we are producing to the court. You need to look at that, because the case may turn on preparing, filing exceptional electronic submissions and documents, and it therefore means that you need to invest more time and resources on your written advocacy. And even in a written advocacy, just like the oral advocacy, you should keep your arguments clear, cogent, concise, and to the point. It's not a time to wonder. You need to remember the 4 words that you've spoken about. Now, you also need to address each issue in dispute. Suffice to mention that what we've been seeing in courts in Kenya, and this is in two divisions, the Constitutional Division of the High Court and the Commercial Division, they're now increasingly limiting the number of pages of submissions that you need to put in. The judge can ask you to put a maximum of 10 pages, a maximum of 3 pages. You should be able, if you're clear and your case is clear, you're concise and to the point, you should be able to write your arguments within the pages that have been allowed by the judge. Now, to give an example of a case that happened in the Canadian appellate court, where the parties, were making submissions on whether to proceed by way of written submissions with a video conference, on highlighting session in April 2020. I mean, this is actually what is mostly happening in Kenya, especially on applications, or to adjourn the matter until, a month in October. Remember, they were in court sometime in April. So they had the option of, going to court and proceeding by way of written submissions in April, or altogether waiting for the matter in October, of course, without the certainty that they'll actually have a physical hearing. And of course, there were issues about the issues and the concerns that you've raised here. Will I be able to present my client's case, effectively or to the best? And this is what the judge said, that the written materials reflect that they were professionally prepared. The appellant's materials presented issues with clarity, and the appellant's position is well developed. And having said that, the court actually proceeded to make an order that the hearing proceed by way of written submissions. I mean, this cannot overemphasize the need of having your written submissions, professionally prepared with clarity, so that the judge is able to understand your cases by looking at that. Now, what about etiquette and ethical standards in our new normal, right? I know Mr. Kepnes has alluded to this, but we can't overemphasize that you need to appear and address the judge with the same formality. My lord, your honor, my lady. I mean, that has not, we have not done away with that. You have to keep that. You need to dress appropriately for the court session. Following court practice directions, if you have directions, in Kenya we have directions on how to dress before certain courts. For example, if you're going to the Court of Appeal, you have to make sure that you're robed. So you need to keep, within the ethical rules on dressing, right? You also need to maintain a quiet and professional background and setting to eliminate distractions. You don't want to be the case that when you're in the middle of your submissions, the court, I mean, I haven't seen this happen in practice, I'm just thinking theoretically, they're looking and trying to figure out the meaning of the art that could be in your background. You need to maintain a quiet and professional background, setting to eliminate distractions. You also need to maintain silence. So if you're not speaking, you preferably mute yourself when other parties are addressing the court. And when it's your time to speak, then you can unmute yourself and speak. Now, what about ethics? I attended a webinar on Saturday, and we are looking at ways, of course, of remaining persuasive to the court. And one of the judges from Singapore actually shared and said that the most distractions he's had in his virtual courtroom is the dogs barking in the background, not even from the lawyers. So that means when you're looking at the silence, silent background, you also need to think about, do you have livestock that can, interfere during the session and know how to deal with them? Do we expect children to come running into the courtroom, for example, because that's a formal courtroom for all intent and purposes. So those are things that you need to think beforehand, because a small distraction can actually throw you off balance, and it also waters down, as the judge said, your professionalism. What about teamwork? I think it will be important that you have, people. I mean, I just wrote 1 to 2 people to assist you in quickly, retrieving exhibits if you need to, and cross-referencing material. Remember, as I said, our time is premium, and you're looking at to utilize the time that will be given to you to the best. So if you can get help to help you retrieve exhibits, for example, to help you do cross-referencing of material, by all means, you make use of that help. Then if possible, have a team present to assist with preparing responses, right, to issues raised by the respondent. So you can have an associate or a partner, whoever the team members are, to help you go through the process. As they said, indeed, no man is an island. And again, just to emphasize that we need to use our time effectively. Now, just to emphasize that most of the traditional advocacy skills, they actually remain on board. It's only that we need now to magnify them because of the new environment that we find ourselves at. Thank you so much, Amor.
Thank you, Faith. Thank you, Faith.
Where is that? I can't see it.
I can still hear you.
Sorry, I had a bit of a challenge with technology. Thank you, Faith, for the good presentation. At this time, I'll be inviting Mr. Olu Salami to take us through the witness and handling of evidence in virtual proceedings.
Good morning, everybody. Greetings from the state of Iowa. As introduced, my name is Olu Salami. I'm an assistant Polk County attorney. I've been a prosecutor here in Polk County, Iowa for the last 17 years. I prosecute felony cases. Those cases are, in terms of consequences, the minimum would be 5 years imprisonment. The maximum would be life without the possibility of parole. And as my learned colleagues had said, we are also here in the state of Iowa now adapting to the virtual courtrooms. And so what I want to do, what my portion of this presentation is to focus on the witnesses, how we handle witnesses in the courtroom. Can people see my PowerPoint? Hello? Hello?
Olu, we can see your face. We are not seeing the PowerPoint.
Okay. Let me make sure it's shared. Can you see it now?
Yes, it's loading. And as it loads, I just want to remind our delegates to make use of the functions of asking questions, because when Olu is done, then the panelists will be attending to your questions.
Thank you.
Olu, proceed.
Okay. So, and is the first, can you see the first slide?
Yes.
Perfect.
Yes, we can.
So, thank you, folks. The way I want to start this presentation, before I get to how the witnesses get into the courtroom, I want it to be understood how the process works here. We have both the United States Constitution and we also have the Iowa Constitution. You should know, and most of you probably know, the United States Constitution was established, helps establish national government and fundamental laws that guarantee basic rights for its citizens. That becomes important in the sense that that's the national requirement, constitutional guarantee. That is, the Sixth Amendment of the United States Constitution is what actually guarantees that in criminal prosecutions, the accused shall enjoy the right to confront the witnesses that I'm about to talk about that are going to testify against him. My state, the state of Iowa, in its state constitution, mirrors the United States Constitution in that all criminal prosecutions here in the state of Iowa that involve life and liberty of an individual, that accused person also has a right to confront any witnesses, any and all witnesses against him or her. And as such, there's this similarity between the federal constitution and the state constitution in the sense that they're substantially the same. This guarantee to confront your witnesses in court. There are other rights too that and rules that we operate under. For example, all court proceedings, similar to other countries, include the defendant's right to a trial that has to be in open court. The public should and always are able to come into the courtroom and observe court proceedings. Defendants or suspects also should have the ability to interact with his or her attorney. The defendants have a right to depose their witnesses before those witnesses appear at trial. So those are some of the important rights that the defendant has, which then requires the government to produce those witnesses in the courtroom. Due to the platform we're using, can somebody confirm if you're still seeing the slides as I click on them, please?
Yes, we can.
Okay, great. Thank you. So, COVID-19. This pandemic, as we now know, has been discussed throughout this presentation, has required us here in the state of Iowa to now move to virtual courtrooms. A year ago, we were handling cases in regular court, in open court. To adjust to the impact of COVID-19, our Supreme Court, which is the highest court in the state, issued several supervisory orders. Those orders addressed emergency and essential matters, and they addressed how we will handle remote hearings. Spelled it out for judges and all participants to know what the procedures are going to be during this difficult times when we're moving to virtual courtrooms. Now, the reason I gave you the constitutional requirements initially is that a defendant has a right to focus you guys on precisely what I do. I'm a criminal prosecutor, so the word defendant is who the charges are brought against. Those defendants have many rights, both constitutional and statutory rights, that we have to comply with as the government who's bringing the charges against the defendant. That one of those rights is that defendant or suspect has a right to a personal appearance in the courtroom. Well, with the COVID-19, the Supreme Court addressed the need for personal appearances by waiver of personal appearances through August 3rd. So far, it's through August 3rd for any proceedings other than the trial and sentencing in which the defendant's personal appearance is required. So the Constitution and the rules of criminal procedure allow for the defendant to be personally present. However, the Supreme Court has said, hey, unless it's a trial right now, you can waive your right to be personally present. The defendant's attorney has to execute a written waiver of appearance, and the district court has to consent. And the district court does that by asking when we're in virtual courtroom, the district court judge would ask the defendant, do you in fact waive your personal presence at this hearing? Or I have received a waiver from you. Did you sign the waiver? And if the answer is yes, we can proceed with the hearing. In the event that the defendant wants to be personally present, then the court also issued an order that allows the good cause, which would be the basis for continuing a case up until a time when the court reopens. And so the rule basically says the court finds that the COVID-19 outbreak constitutes good cause within the meaning of Iowa Rules of Criminal Procedure 2.33 for any trial postponement. And what that simply means is this: a defendant has certain rights. For example, that defendant has a right to a trial within 90 days of the trial information, the charging document being filed. If a defendant insists on being present and doesn't want to appear in virtual court, then the judge can continue that case. And in this case, in my state, many cases have been continued till September of 2020, when the court thinks we may be able to resume public trials or hearings in a courtroom. So the defendant now, even though he has a constitutional right to a trial within 90 days, because of the COVID-19, the courts now have the authority to establish good cause to continue it in cases or instances where the defendant does not want to waive his or her personal right, which in effect just means he or she doesn't want to participate in a virtual courtroom. Now, what happens again before we even get into the virtual courtroom and then me talking about how we handle those witnesses? The defendant has to agree to appear via video conferencing, as I said, by signing a waiver of his or her right. And if the defendant doesn't do so, the court gets to continue it to a future date that the defendant can be present. And that would be hopefully when COVID situation has been, it's no longer a health risk to the public. Those witnesses that we have to handle in a virtual courtroom, the way we get them into the virtual courtroom here in Iowa is both parties, either myself on behalf of the government or the defendant and or his or her attorney, have subpoena powers. Those subpoena powers allow us to subpoena witnesses to the courtroom. But in this case, since it's going to be a virtual courtroom, my office or the clerk's office or the court attendant will provide the login information on the subpoena to the witnesses. So on the subpoena, we would list out, for example, here's your login credentials. This is the platform we will be using, and this is how you log in. Because it's critical that we get our witnesses, even in a virtual courtroom, to attend, my legal assistants and or me as an attorney or other attorneys in my office, we actually follow up with our witnesses ahead of the hearing regarding the receipt of subpoenas and their ability to log in. So I would call in and say, Ms. Smith, we have a hearing next week. I want to make sure that you receive the subpoena. I want to make sure that you also noted that on the subpoena, it has the login information. We will be going in through Zoom, or we will be utilizing the GoToMeetings platform. So it's important that we know that you have all this information and be prepared to log in about 5-10 minutes prior to the hearing starting. There's an example of subpoena power that's it's not an invitation. They now know that, as you can see with the 3 X's, they are commanded to appear in the District Court of Iowa, Polk County. But in this case, we will tweak it by video conferencing on so date. And subpoena powers are very important powers here, because failure to comply with a subpoena means you could be held in contempt of court. So we nicely explain to witnesses that even though you are appearing remotely, you're required to. It's not an invitation, it's a command by the court. So you need to abide by that. Otherwise, you subject yourself to possible sanctions and or possibly up to 6 months in jail for failing to appear. What are some of the challenges we face in trying to get the witnesses to the court? One, do they have the devices to log in? as much as we know the technology advancement across the world with access to laptops, with access to personal devices such as iPads and phones, we still know that some of our witnesses do not have those. So those are some of the challenges we have as to whether or not they actually have the device necessary to log in. And when they do log in, we notice that sometimes witnesses are informal. So, and I will talk about how we try to prepare them for the virtual courtroom appearance, but it's not unusual where we have situations where they're too informal. One of the fears I have as a prosecutor is that when you have, if they are able to log in, but there are other individuals in the background feeding them information. That's a concern we have virtually because we can't see who's in the background whispering to the witness. It was about a couple of weeks ago, we were litigating matters regarding restitution, and the question was posed to the witness, how much is the restitution? And you could see the witness look to the right and say, hey, how much was the rest? And then comes back, $1,300. That gave me a cue that there's somebody else in the room feeding information. So that's kind of some of the challenges, as you could imagine, would be. It's not unusual. There's once in a while, there's a lack of respect for the proceedings. Again, my learned colleagues have talked about the need, the professionalism required, even from witnesses. That's a requirement. We've had people pull over their car when they realize, oh, I'm supposed to log in, and they're in a t-shirt that says, drink a lot of beer on the weekends. Things like that, that informal or lack of respect for the courtroom is concerning. Also a challenge is how do we produce documents that we need to the witnesses? It's required new strategies, obviously, and new methods of doing that. But because in a courtroom, you know, you could have your legal assistant prior to the trial go over some of the evidence and the like. But now, do we email some of the documents that they have to review prior to the trial? And so we're looking for creative ways on how we produce those documents to the witnesses ahead of time so they're familiar with the documents, so that when we do ask questions, they're better prepared, as opposed to trying to go through a 10-page report to highlight a particular paragraph. Other challenges is, and we've talked a little bit about that, sometimes we're unable to replicate the effects of testifying in open court. There's nothing better. We do more jury trials than bench trials because, as you probably know, in the United States, defendants are entitled to jury trials. So the effects of having 12 people when you walk across the room to hand over what you know is damning evidence and you want to use that to cross, you kind of lose that during virtual courtrooms. We're also unable to take advantage of all the technologies we have in the courtroom. Ironically, nobody predicted the COVID, but what they have been working on in my jurisdiction and across the country is improving the technology. We just built a brand new courthouse with state-of-the-art technology, whereby the witness on the witness stand actually has a monitor, and I can publish a photograph from my desk in the courtroom and ask the witness to mark a certain injury on the photograph and then have the judge capture it. All those technologies that we have available in the courtroom, those are some of the challenges we face with witnesses in the in virtual court. And you know, it's still, I'm glad to hear that in many countries, efforts are being made for to provide court reporters. We don't have to worry about a judge writing down questions or responses or arguments, because all that is taken down by a court reporter. But the challenge in virtual courtroom is to get witnesses to know, as you said so correctly, one of my colleagues, about pacing themselves, because it's still a court reporter and they do have a remarkable ability to take down every word, even when said at a fast pace, but we still are conscious of that fact that we need to slow down a little bit, and to get witnesses in a virtual courtroom to learn to do that is also some of the challenges we face in the virtual courtroom. To overcome some of those problems that I've highlighted in the virtual courtroom, we now do even more preparation by going over the facts, the law, and the evidence with witnesses before we get to trial. It is important that you know that we are not allowed to coach our witnesses as to the answers they have to give, but we at least get to reiterate what the facts are. They get to know what we need to prove. We talk to them about the background while they're attending the hearings. Make sure you're in a quiet area. Make sure you're in an isolated area if possible. Be presentable. Make sure there are no interruptions. All this essential things that we think would enhance the experience during the virtual hearing. Their demeanor during procedures, which we've talked about. Now, to make admissions of exhibits and evidence easier to admit, because now we're going through virtual courtrooms, what we tend to do is we produce the exhibits and other evidence to opposing counsel prior to trial. We already have an electronic filing system. We've had that for years. Everything we do is paperless. From the filing of my appearance as the counsel for the state, that appearance is filed electronically. Within 5 seconds of a document being filed, we're notified on our smartphones, on our emails, that a motion or pleading has been filed. The reason I highlight that for purposes of the witnesses is that we, in many cases, for example, we would file the photographs. For example, if we have 10 photographs of the crime scene, we would upload that to the case file electronically. So the judge has an opportunity to review those. The opposing counsel has an opportunity to see the photographs that I intend to publish. And in fact, nowadays, the courts require parties to upload exhibits. Now, there's a caveat. We still have issues with what we can upload. We're having difficulties, or quite frankly, we've been unable at this junction to upload video evidence. So if I have a surveillance camera that captures a robbery or a murder case, we have to copy that surveillance video to a disk and then physically hand the disk to the court for purposes of preservation on appellate issues. If I were to click on this link, the iowacourts.state.ia.us, EF file, electronic filing, it would take you to the website that I would then have to simply log my credentials, and I can pull up every single one of my cases ever since we started electronic filing several years ago. People like all over the world, people were resistant to electronic finals, but it's made life a little bit easier during the COVID crisis because we already have a system in place of electronic filings. And so it's made things easier. As it relates to when you do bring the witnesses into the courtroom, in virtual courtrooms, you have to make sure as the lawyer, myself as the prosecutor, speaking mostly for prosecutors, we want to make sure we're organized. We want to know what we're going to emphasize during that proceeding. We want to make sure there's a link with the facts and the law and what the expectations are. When necessary, be very clear on pulling the sting. For example, if I have a victim that I know has committed a theft before and been not only committed a theft, but being convicted of a theft. A theft crime is a crime of dishonesty. So I know that the opposing counsel, even in virtual courtroom, is going to question my victim about being a convict or being convicted of theft. You pull out the string during your direct examination by saying, Miss Smith, isn't it true that you've been previously convicted of theft? That pulls the string. Another thing we do, like I talked about, witness preparation. And then as a prosecutor, even in virtual courtrooms, I try to fade away. What do I mean by fading away? Other than, sorry, before I get to the fading away, make sure you ask open-ended questions. Make sure they're short, simple questions that a jury or a judge would have asked had they had the opportunity. Find the excitement in whatever it is that you're arguing, bring it out, and then fade away. The reason you want to be clear and concise, otherwise you're going to have funny answers to question, even in virtual courtroom where the witness is not fully prepared. For example, a question was asked, what was the first thing your husband said to you when he woke up? He said, where am I, Kathy? And the next follow-up question was, and why did that upset you? She said, my name is Susan. You could imagine what problems without being prepared before trial. Many questions like that. Now, doctor, isn't it true that when a person dies in his sleep, he doesn't know what he's talking about until the next morning? The point being, you have to be prepared. You have to prepare your witnesses so that you don't get answers that would surprise you even in virtual court. I'll move through those very fast because I know time is of the essence, but I had questions. And then when you fade away, even in virtual courtrooms, the idea is just tell a story, stay out of the way, but nudge it towards what the details are that you need. The story is first, lawyers' questions later, even in virtual courtrooms, because you want to keep it, as my colleague said, concise. Separate later pockets for if you have to clarify things. Make sure you have the facts, and let there be an educational component to the judge in this case. Once again, the story with visuals, and story and physical. This is still difficult in virtual courtrooms because of how do we present it. But if you're going to present, for example, make sure your visuals are very clear. This is an example of spent shell casings that were recovered. Make sure the judge and everybody visually, remote, could see what you're doing. Make sure they're clear in explaining, even though it's virtual courtrooms, your evidence or your exhibits are very clear that they would show. So, as I said, you organize, you emphasize, you pull the string, and very, very briefly, I have a couple of slides. When you're going to cross-examine, especially in virtual courtrooms now, you try to decide whether or not you need to cross at all. Lawyers, we think we always have to talk, but if the evidence comes in so well that there's no need, then don't. If you do decide to cross in virtual courtrooms because of how you want to manage this platform, just elicit favorable information first, then if necessary, try to discredit the information, the scope of knowledge, whatever the perception is, any biases that you think, any contradictions. And even in virtual courtrooms, we try to be brief. We try to ask short questions, use plain words. You lead, isn't it true that you shot Mr. Smith 5 times? Always know the answers. You don't want to be surprised. Ask a question you don't know the answer, especially in a virtual courtroom, because it may be hard to come back from that. Listen to the answers. Don't quarrel with your witnesses. You don't even have the time, because with virtual courtrooms, they are reducing the number of time we've got in the courtroom. So I'm not going to spend time quarreling with the witnesses. I don't rehash what has been testified to. I try to not let the witness explain, though, because it's cross-examination. and I don't ask one more question too many. And you want to save your ultimate point, even in virtual court, for the closing arguments. We're allowed to redirect a witness if necessary. I always say the word is short when it comes to redirecting a witness. If it ain't broke, don't fix it. The 3 topics max. Ideally, 1 question per topic. Hopefully I sped through it because I knew time was of the essence, but that's kind of the crux of what it means. There's still more questions than answers because we are also adapting to virtual courtrooms in the United States and specifically my jurisdiction, but it's a work in progress. And we have suspended jury trials till we are able to get folks back in open court, but we've been able to handle other types of hearings and limited trials. Thank you.
Thank you so much, Olu. That was a powerful presentation. And to our delegates, please, we thank you for your patience. You've been with us through the last 2 hours. We ask you for patience for another 15 minutes so that we can deal with some of the questions that are coming up and we can get more wisdom from our presenters. Now, Mr. Kepnes, there's a question which has come through. It was directed at Judge Wallace, not in the room. But I believe
I am here now.
Oh, thank you, Judge Wallace. One of our
take a break.
Thank you. One of our delegates is asking that in 3rd world countries, there's a serious issue about internet connectivity, and asking whether this would prejudice a counsel in a courtroom, and how do we navigate this challenge, which is basically an infrastructural issue?
So we have dealt with those issues. Presumably we have some better connectivity, but I think everybody was challenged during this time. I have 2 teenage daughters, a college student and a high school student, and my wife works as a speech therapist. So all 4 of us were using the same internet from the house at times. But I think generally the way the court has handled it is that we're open to those situations. If people can't be present through their computer, then phone calls and the like, as long as, you know, whatever we can do. And that's initially how we've dealt with it, because mostly we've dealt with emergency proceedings and deferred everything else. Like Iowa, we are not holding jury trials until at least October because of all the logistics involved in that. But it's going to be a challenge. While I have the floor, I did see that there was another question about how does the court ensure recording and preservation of the record. So initially we are using programs. Zoom for Government is the one that we've been using, which does record the proceedings. Now that a little time is passed and we are broadening beyond just emergencies, we have reopened the courthouse to employees. And so when I conduct a virtual hearing now, I'm doing that from my courtroom. And so in addition to the program's recording of the proceedings, we have our usual recording system. We use a CourtSmart system in most courtrooms, and then we have court reporters and others. If the CourtSmart doesn't work, we have the court reporter as a participant online, and they are taking it in the same manner that they always do. And then the last question that I saw that looks like I might be able to address was that there are no preset rules for the presentation, and judges are expressing their own preferences and the like. That is true, but that is consistent with the way courts, judges here in Maryland and in the District of Columbia, Washington, D.C., where I've practiced, always do it. Judges have their own preferences, and they're allowed to have their own preferences in terms of order of presentation and the like within the framework of the rules of procedure and evidence. So, the way I've handled it is I'm understanding of that, and I will tell people, because of what I talked about earlier about people speaking over each other and the like, I will start every hearing with having every participant identify themselves, confirming that they can hear me and that I can hear them. And then once we've done that, I'll generally lay out the questions. You know, this is the procedure we're going to follow. I'm going to ask the question of A, and then a question of B, and then A will get a chance to examine, and that kind of thing. Those are within the historically appropriate powers of a judge to administer their hearing, provided that you don't violate the rules of procedure or the rules of evidence. So that's kind of the way that we've been dealing with it. It's okay. The last question, I think, was, should parties be allowed to opt out? I think opting out would be a big problem, particularly in the criminal realm. It gives some criminal defendants, the ones that are detained, with kind of a Hobson's choice. Do I defer my trial for 6 months or a year because I can't deal with, I don't like the virtual setting. So far, it'll be at least 6 months, 7 months that that we won't be having jury trials to determine guilt or innocence. That is already kind of an issue that's out there, and our Supreme Court, which we call the Court of Appeals of Maryland, has issued an order that says that all deadlines, we have a speedy trial rule, and some of those, that all those are deferred during the period of the COVID shutdown. But we do have a United States constitutional issue for speedy trials as well, which is not a set deadline, but it's kind of a broader category with factors. And I mean, I am, of course, concerned that somebody who is locked up awaiting trial may have to wait 7, 8, 10 months or a year to have their trial come before them. So that is an issue. But opting out, I think, has until we know what this is going to happen, and we are now experiencing a resurgence of cases from those states in the United States that reopened. So I think this is going to be with us for the foreseeable future. So I'm not sure that I personally would advocate for an opting out system. We do try to accommodate as much as possible all the issues that in dealing with this new arrangement. But I think having a party opt out completely, at least in a criminal context, would be problematic.
Thank you, Judge.
My pleasure.
Thank you. Thank you so much, Judge. The second question coming from Emily, and she's asking Faith and Olu that what are some of the challenges that virtual courtroom proceedings have posed when it comes to cross-examination of witnesses? In fact, I had another question related to that Olu, you could also type in, especially the fact that in virtual courtroom, counsel cannot fully see the witness. Probably they are only seeing their faces. Is it taking away the advantage of nonverbal cues, especially in cross-examination?
Huntington, if I could just jump in on the issue of third world connectivity that the judge addressed with a slight perspective before Olu jumps in, is that right?
Absolutely.
So in terms of third world connectivity and the fact that this would prejudice litigant proceedings, it is a very real concern. However, two things come to mind. As far as Kenya is concerned, Article 159 of our Constitution does provide that when justice is being administered, it shall be done so without without due regard to procedural technicalities. In other words, there won't be an undue focus on it if indeed it will result in a perception with the litigant. They leave the courtroom feeling that justice wasn't done. To my view, a wide latitude of interpretation to this particular article would provide that courtrooms would be very conscious of the fact that litigants need to be able to have connectivity. I think one of the judges that Faith Masharia referred to, one of my absolute favorite judges in terms of appearing before his courtroom, Justice Majanja, very acutely aware about technology, but is very conscious to the fact that even counsel who come late, typically you come late to court, any other judge, you might get your matter kicked out, fix another date later in the registry, depending on what it is. But he's very conscious of the fact that you might come in, your matter is not listed. He'll indulge you, in other words. The judge will exercise discretion. In my view, this is the answer to your question. The court should exercise discretion to allow a deferment of the proceedings if indeed a litigant or a witness cannot access easily or cannot be heard, or there's a problem with technology. However, there needs to be a transitional phase where litigants, advocates, the courts are beginning to become more comfortable, the platforms are becoming more reliable before you get to a place where more strictures can be applied. Lastly, you would be surprised to know, I don't know where you're from in terms of East Africa, but the East African countries have a very high degree of connectivity in Africa. Kenya, as a matter of fact, has the best connectivity in Africa, way better than South Africa, way better than Egypt, pick any country. In other words, our service providers have done a lot to provide reliable internet access. So all you need to assure yourself, therefore, at least a judiciary in this case, is to get a reliable platform that takes into account, issues of bandwidth, issues of video output, issues of audio output, that whole robustness. But in terms of connectivity, that service is available today, whoever is seeking to use it, whether it's a judiciary or otherwise. Thank you. Sorry, Olu.
No, it's great information. And it's also very nice to hear about how East Africa has, great connectivity abilities. Just to follow up on the question regarding cross-examination, obviously there is a difference when you're doing it remotely. Ideally, it would be great in the courtroom, and especially from my experience, 99% of the time there's a jury there. So being able to cross-examine a witness using audio, video, documentation would be, my preference would be to do it in the courtroom, but virtually now you've learned to adapt by, having shorter questions, recognizing there's that delay in response, and that delay gives the witness time sometimes to think, that extra second to think of a possible different answer than would have if I was able to say, isn't it true that you were there at 6 o'clock? Isn't it true upon getting there? Isn't it true? We have to adjust, and recognizing that, yes, cross-examination is one of the tools that we need to successfully, hopefully, give the full picture of whatever it is that we're trying to litigate. However, I've come to rely more now, or would come to rely more on closing arguments to tie all those links together, because I know the cross-examination does not have the same effect in open court than it has in virtual courtrooms. Therefore, while you still engage in cross-examination, you then try to be even more persuasive when the time to give a summary argument or a closing argument. That's at least how I try to handle it. I'll defer to Faith.
Yeah, thank you, Olu. Let me start by mentioning a case that was reported in Canada, and this was the case of the Law Society of Alberta versus Adelowokan, an interesting name. The Law Society is actually on record for reprimanding a lawyer for her conduct during an immigration hearing conducted through a video conference. So what the lawyer was doing is that she was whispering answers which were then taken up by the client and repeated to the panel members' questions. I mean, these such challenges are not unique to that jurisdiction. We are facing similar challenges here at home, especially because you're not able to have a 360 view of the office. And this goes back to the topic that we discussed earlier. Where are our ethics? Do we throw them out of the window because we're having virtual hearings? These are the things that we need to bear in mind. In one of the cases that I did recently, the judge actually asked one of the witnesses to confirm whether he or she was alone in the room. And after she confirmed, then the judge asked her to do a 360 camera view of the room because of these increasingly challenges that we are seeing. But we don't need to go to that extent. We just need to abide by our ethics. That is some of the challenges. The other thing is that the cross-examination, I find it is taking longer, so to speak, especially when the other side have not prepared their witnesses, to go through the bundle. And also, especially here in Kenya, it's not odd to find a bundle that is not properly paginated. So it takes you more time to refer to you want to cross-examine on a certain document. So it will take minutes. They're still trying to find where the page is. But some of these challenges can be overcome. You need to think about the trial beforehand. So when you're going for mention to confirm in Kenya, under the process, you need to go for a mention to confirm, a pre-trial mention to confirm that the matter is ripe for hearing. So you need to have gone through the documents. If you notice, for example, that the opponent's bundle, it's not properly paginated, it's not proper, the witness statements are not, do not properly cross-reference the documents. These are some of the things that you need to bring to the attention of the judge, because it's going to cost you, it's going to take your time during cross-examination. So the preparation of the hearing starts beforehand, and you have to think from the beginning before you even get to the hearing of the matter.
Thank you, Faith. Kepnes, there's the question about openness of the justice process, that there's a lot of limitation in accessing the virtual courts, probably to limit the bandwidth. Do you think this is a threat to the well-known open justice?
A simple answer to that question is, for the time being, there definitely is a threat to open justice. There's a threat to the transparency of court proceedings, because the public cannot access as freely as they would previously. The media, who are on the other hand a means through which the public access information about a case, are also not able to access. And it's not because they are disallowed, it is simply because the way the system, the platform, the transition is happening now, the court is concerned more about the litigants and the counsel. So I think it's fairly temporal. However, as temporal as that might be, I certainly think that there are cases of public interest, great public interest, which the media would have picked up on, either when they were filed, or some form of intimation from a registry source, etc. The media ought to be able to a priori seek the approval or the consent of the judge to be in that courtroom, so that they get a copy of the link and they're able to link in the courtroom, sit and listen, of course, observing the decorum that's necessary. As a sort of intervening measure, I think that as we move forward, it will become crucial for the court to make a more deliberate attempt to ensure open justice is restored. And this is one way, could be through ensuring that the court could choose to broadcast the proceedings. The court could choose to make the links available to various media houses. But in that regard, the court also needs to make sure that the platform they're using can allow, an almost indeterminate number of people, because some of these platforms operate at a premium when they have not more than a certain number. So if you're using a platform that can only take people, and there's more than 50 people who seek to come in, then the quality of the proceedings, the quality of reporting will be severely compromised. So I think it's a temporal issue. I believe the judiciary is seeking to address that issue. Hopefully time will tell that they're responding in a positive way, again through using technology to ensure open justice principles are preserved.
Thank you, Kepnes. Now, in the interest of time, we are about to wrap up. But before we do this, I would like Olu to answer one question. Then we'll direct some 2 questions to the judge to wrap up for us. So Olu, Jack is asking, what is your experience with unrepresented defendants, and how do you ensure that they are served way within time, or they are able to access documents way within time, as opposed to established law firms which have a channel of receiving them? And do you find unrepresented defendants receptive to virtual proceedings?
I deal less with unrepresented defendants because we're at the felony level. The court does everything in its power, and so do I, to encourage a litigant to secure counsel. If it's due to lack of funds, we advise the pro se, we call them pro se person, unrepresented person, that an attorney can be appointed, and the state would pay for his or her representation. So as a practical matter, I do not come across it, but I'm one of many attorneys. I do know that in the indictable dockets, which are the kind of lesser offenses dockets, where you have more unrepresented individuals, they sign up like everybody with an email. With the email, they have access to every single document that is filed, because as I told you, everything is done electronically. And so that's the way they communicate. They have to sign off on that they're unrepresented and that they're willing to speak with the prosecutor. That puts a lot of pressure on the prosecutor, and as one of the presenters said, we have ethics. I think we work even harder when we have an unrepresented person, because I have an ethical obligation, my colleagues have an ethical obligation to make sure that you do not take advantage of the lack of experience of an unrepresented individual. So it is critical that we are forthright. It is critical that we, even though it's an adversarial proceeding, we still let them know where to look for the evidence, where the law is, what the code section is, and that at any point, if they decide to secure an attorney, we would stop all discussions and afford them the opportunity to obtain an attorney and then maybe restart the process. So in a nutshell, it's always difficult working with unrepresented, because we believe we have to bend over backwards to ensure that their rights are not violated. But the courts in the state of Iowa do an extremely good job of encouraging unrepresented people to have trials. So I think in my entire 17-year career, I've only had 1 or 2 trials at the more advanced level of people who are unrepresented. However, if it's traffic court or petty theft, then they are treated just like attorneys. They're expected to, we tell them what the rules are, we tell them we go first. They don't have to prove their innocence. We just go through the basic crash course of what they should expect in court.
Thank you, Olu. Is the judge still in the room? Judge Wallace, are you still in the room? I cannot hear Judge Wallace.
Hello, Huntington. I think we can take another question for another speaker as I get hold of him.
That's okay. Now, Faith, I come back to you, Faith. You had spoken about the importance of documentation prior to the court date. is this the new normal? Does it mean that now more than ever, cases are going to be won or lost on documentation? How thorough you prepare your documents? And if this is the case, then what new skills are you advising lawyers to learn to ensure that they are able to comply and remain competitive?
Yep. Thanks, Amal. I think I'll speak out of my experience in Kenya. Before the new normal, this is pre-COVID, we used to argue most of our cases, talk about applications, talk about constitutional petitions, orally, so to speak. But what you have seen post-COVID and pursuant to directions that they've been given and updated by the Chief Justice on the conduct of court business, parties have been encouraged by the court to proceed by way of written submissions. So we have the constitutional petitions being, proceeding by way of written submissions. You have your applications proceeding by way of written submissions. Of course, for the witness trial, it has to go through the trial. But then you proceed by way of written submissions, then you're given a very limited time to highlight your submissions. So it is true that most of the matters now, unlike pre-COVID situation, they're being determined exclusively on written submissions. So what does this mean? And just to mention, and I had earlier mentioned that, we are even getting directions on the length. How long should your submissions be, for example? So this calls for us to be precise. And I think I spoke about the 4 points. You need to be precise and you need to go straight to the point. There's no time, you're not allowed to file 40 pages of submissions in Kenya. So you really need to understand your case properly, understand the important facts that you must be brought to the attention of the court. And those are the things that need to go to your written submissions. There's no time for sideshows anymore. You don't need to spend time on undisputed facts, for example. You need to choose the facts that you need to address on which the determination of your case turns.
Thank you, Faith. I believe the judge may or may not join us. I would like to give each one of you an opportunity to give a parting shot before we take the vote of thanks. So Olu, may I start with you, then Kepnes, then Faith.
Thank you. First and foremost, I want to again express my sincere gratitude for being invited to participate in this important workshop. It truly is a process that I want to give back whenever I can. So I appreciate the invitation and would extend my participation in the future whenever needed. That being said, all the presenters today have eloquently identified the direction that we are going with virtual courtrooms. While there's a tendency that we, at least in my jurisdiction, are going to return to open courtrooms, there's still a lot from virtual courtrooms that we think are here to stay. And as such, we're going to, my understanding in speaking to judges, in speaking to colleagues, many of what's going on, we are going to retain. It's still jury trials, actual bench trials will still be held in the courtroom when we open back up. But this pandemic has forced us to rethink, how we process cases. It's led to more cases being resolved because of the pandemic. We have folks who normally will not take a plea deal, recognizing they may not have a trial now for about a year. And so we're working, all sides are encouraged to work closer to plea agreements, and only cases that there is absolutely no ability to resolve are actually going to trials. In parting, I would say to to the listeners that we all have obligations as lawyers to be professional, to bring ourselves up to speed with the laws of our different jurisdictions. But as a prosecutor, it just matters to me that our ethics should should always guide us in everything that we do. When clients, defendants come to us, most of you that are, if you're on the defense, or when it's witnesses on our behalf, we have an ethical obligation to always do things right. And the best job we do should be when nobody's watching. Thank you.
Well, EALS and AGA Africa, this obviously has been a privilege, the opportunity to share my learnings, obviously be a student as well, to hear from my colleagues Faith and Olu. Each time you share my experiences, you get to learn a bit more about the material that you're sharing. But really, my parting shot to my colleagues who are listening in is this is in fact an opportunity to become better advocates. This is an opportunity to help increase, enhance the expedition of administration of justice as partners of the judiciary. It would not help your clients, it certainly wouldn't help you to be difficult about adopting to the thresholds, the new thresholds we are finding ourselves being presented with. So I would encourage each of us to willingly come to grips, go out of your way to get comfortable with the use of the technology. That's one. Go out of your way to become a better advocate. As Faith has shared, you no longer have time for side feeds. I think one of the frustrating things for me and many of my colleagues at the bar is that counsel is given, 5 minutes or 10 minutes or half an hour, whatever it is, to submit, and they are not saying anything that cannot be said in half the time they take. Counsel is reading through their submissions. You're not exercising advocacy, you're not arguing. So this is a chance for us to become better in our advocacy skill, which ultimately will benefit not just the bar, but the bench and overall the administration of justice. Let's be positive about what COVID has given us. Thank you.
Thank you, Amal, for the opportunity. In parting, I'll say that I cannot overemphasize the importance of preparation. There is nothing that can replace preparation. Just like you prepare to go to a physical hearing, you go before time, you lay down your files, you know where you'll be standing, even sure your witnesses where they will be, they'll be taking the evidence from. You need to prepare for virtual hearing. It's a court. It's a court behind a computer, but for all intended purposes, it is a court. You need to prepare. You need to prepare for that. Now, if you're expecting internet disruptions, for example, I know Mr. Kepnes spoke to this, you can think about having alternative internet connectivity sources, and I've always done this. So I'll have maybe two Wi-Fi, so to speak. I can get a Wi-Fi, which is readily available in this country. And if you're online, you can think about hotspotting. But for you to be able to do this, you need to be familiar with technology. As advocates, you cannot remain behind. You need to familiarize yourself with the technology. This is where we are. We don't know for how long we remain here. And as you're speaking, it's likely to change the way the court processes are going forward, especially in this country. So we cannot overemphasize again the importance of preparation. We need to be prepared. Thank you, Amal.
Thank you so much, Faith, Steve, and Olu, and Judge Wallace. It's been a pleasure having you this afternoon. And I also thank our colleagues who have been listening through. Even as I invite Lillian to give the vote of thanks and close this session, I would like to remind us that this is just the first in a series. On 8th of July, just in a week's time, we will be holding a session on data protection, especially targeting lawyers and addressing emerging issues. This is a hot area, and we invite you to join us. You'll be seeing the poster very soon. On 15th of July, we will be discussing an interesting area, that is digital forensic, touching on how lawyers interact with forensic evidence in the digital era, and how you can maximize out of it to ensure that you tilt the balance of the case in favor of your clients. And finally, on 22nd of July, we will be addressing a subject that AGA has the most expertise in all over the world, that is transnational crime in the 21st century. Again, we'll be inviting you to join us for this session. Once again, thank you for finding time to be with us. Lillian, please.
Rightfully so, Huntington. We have 3 upcoming webinar series. The link for next week will be shared on Friday at midday. Many thanks for moderating this session. I take this opportunity on behalf of AGA Africa to appreciate all of you. We have had a very enlightening session this afternoon, and we have learned a great deal. We can all attest to that. A big thank you to all our speakers, Honorable Judge Wallace, Mr. Olusalami, Stephen Kepnes, Ms. Faith Masharia for the insightful session on the key advocacy techniques in virtual court proceedings. As we say in Swahili, asante sana, meaning thank you. Ladies and gentlemen, we cannot thank everyone enough from the ELS for your involvement in this webinar. Just to emphasize, we as AGA Africa, our core mandate area is training of investigators, prosecutors, judges, and magistrates and other law enforcement officers in the investigation and prosecution of transnational criminal activity, and also participation in seminars, other events to educate, increase public awareness, and draw attention to the dangers of transnational crimes. We are currently working in 8 African countries, namely Ghana, Kenya, Malawi, Nigeria, Rwanda, South Africa, Uganda, and Zambia. Follow our social media pages at AGA Africa for more information on emerging trends on transnational criminal activities. The same has been posted in the chat box below. Asanteni sana, and see you next week on Wednesday in the next webinar on data protection. Thank you and have a lovely evening.